Thank you, Mr. Speaker. There's no easy button on this issue. And that's why we've been talking about it for years and years and years, and why it is so contentious. It's also why we don't have a national standard on this issue. And I want to say right up front, because we don't do this enough in this conversation about guns, that I understand the views of those who are in favor of this bill, and I respect them. I have a different view, and I hope that you will respect it as well. I've listened to all the remarks today very, very carefully. And one important point that I do want to acknowledge is that while we have talked about this bill for years, when it was brought to committee, there was no opportunity for the public to comment. And I think that that's wrong. I think that on an issue that is this important, that people on both sides care so passionately about, there should have been an opportunity for the public to have their views expressed, even if we've heard them before. What we know is this. We know that a majority of Georgians do not want this, let alone the chancellor, the regents, presidents of universities, professors, moms and dads, and many students. These, and not us legislators who do not have to run or live on a campus, are the people who will feel the greatest impact if this bill becomes law, and we aren't listening to them. I'm humble and self-aware enough to know that I'm not going to change any minds or votes with my remarks, but I want to explain fully why I don't support this bill. In America and in Georgia, there is a right to bear arms, one that has been ingrained in our culture. And what has also been ingrained in our culture is a tradition of not allowing guns everywhere for everyone. Instead, we've regulated guns to limit their negative impact on innocent lives. Traditionally, this issue has not been black and white and all or nothing. And that's because there has never been a total prohibition or a total free-for-all. And there likely never will be. And I fully understand the self-defense argument. And it's true that we have an inherent right under natural law to self-defense. I get it. And for lawful permit holders, I understand that you want to be able to protect yourselves and others. But our application of the Second Amendment here in Georgia, and candidly across our country, doesn't allow permit holders to carry anywhere. On the contrary, there have always been and always will be places where a lawful permit holder cannot carry. So there is a tension. For example, we restrict access to government buildings where there are metal detectors and guards present. We restrict access to courtrooms. We restrict access to athletic facilities, both public and private, and even on college campuses in this bill. And also under this bill, we will continue to restrict guns in dormitories and in sorority and fraternity houses. Let us also acknowledge that private property owners can prohibit guns on their property. In fact, one of the explicit arguments used to pass a bill a few years ago was that we should authorize guns in churches and bars because those are private properties and they can make the decision for themselves. In sum, the rights that are secured under the Second Amendment are not absolute. We should acknowledge that. In many places in America, guns have traditionally been a daily part of life, including for many people, families, and communities in regions here in Georgia. Yet this way of life, which should be respected, has actually peacefully coexisted with reasonable regulations that make firearms off limits in certain sensitive places, such as schools and college campuses. And this has been true since our nation's founding. So, while guns have long been important to so many people and in so many communities in places like Atlanta, Athens, Savannah, Valdosta, and Kennesaw, for just as long a time, institutions like Georgia State, UGA, Valdosta State, and Kennesaw State have been gun-free. And this is true of American culture in general. For even our founding fathers, like Thomas Jefferson, the author of the Declaration of Independence, and James Madison, the father of our Constitution, who were members of the University of Virginia's Board of Visitors at its founding, supported keeping college campuses clear of firearms. We don't need to guess the views of our founding fathers. We know them. And that is why I will say that our current law is absolutely constitutional, 100%. It's not even a question. If there were a court challenge, it would fail. So what we're dealing with today is a political question, a policy choice. And that is why we have different laws regarding campus carry across the country. There is no established standard. And here is another part of the debate that is interesting. This bill does not apply to private and independent schools, and they will continue to be able to forbid firearms on campuses. For those of you who believe that the private sector usually gets it right over the public sector, they're going in a different direction. I know that there's been some discussion about students who support the bill, and believe me, I respect their views. I understand their concerns. But I've also spoken with many who have different views and don't want guns on campuses. I've spoken with professors, both in the district that I represent and beyond, and none of them want HB 859 to become law. In fact, one, a conservative who lives in my district and has a bumper sticker that says, "You have all of your rights because of the Second Amendment," and I think the gentleman from Douglasville may have a similar bumper sticker. He also teaches at a public campus, and he adamantly opposes this bill and called me and said, "Please do not support this bill. I do not want guns in my classroom." So the views of those who work on college campuses and the views of students and their moms and their dads who don't want this should be considered. Now, Justice Scalia, and we heard a little bit about him, may he rest in peace, was absolutely a conservative and a strong one at that. And he wrote, as we heard, one of the main cases on gun rights, District of Columbia versus Heller. And what that case was about, if you can believe this, and it was only a few years ago, was the right to have a gun in one's home. Not on a college campus. That made it to the United States Supreme Court, a case about having a gun in one's home. And he was very clear, and he is an originalist. And he held, as we heard, these are his words, not mine, like most rights, the right secured by the Second Amendment is not unlimited. He then said, although we do not undertake an exhaustive historical analysis, there is nothing in our opinion that would prevent keeping guns from schools. We know the opinion of Justice Scalia. We know the opinion of our founding fathers. And those of us who are voting against this bill are voting with Jefferson and Madison today. I hope that you will join us. Thank you, Mr. Speaker. I yield the well.